Robert Dawson, student number 1600197. Good morning, my name is Robert Dawson. I am acting as counsel on behalf of Jarndyce in an oral hearing held here today in London, in respect of a challenge brought by Rolafun of Dr. Gargin's impartiality and independence as President Arbitrator of the arbitration proceedings in question. Rolafun have challenged the position of Dr. Gargin as President Arbitrator under Article 10 of the LCA Arbitration Rules and Section 24 of the Arbitration Act 1996 on the basis that the following circumstances give rise to justifiable doubts as to his impartiality or independence. Firstly, Dr. Gargin authored an article where he advocated a relaxed approach to the performance of contracts in the amusement industry. Secondly, Dr. Gargin is connected on LinkedIn with all the counsel for both Rolafun and Jarndyce. Thirdly, one of the lawyers for Jarndyce has provided a laudatory recommendation for Dr. Gargin related to a case where they both worked a year ago. And fourthly, Dr. Gargin, the President Arbitrator, once got into a drunken skirmish with Mr. Howie, a member of the Board of Directors of Funny Tank Engines Limited, which has the same parent company as Rolafun. Each of these points will be dealt with in turn. Firstly, the article that Dr. Gargin authored advocated a relaxed approach to the performance of contracts in the amusement industry. The case of Ubasa v Argentina provides us with the general rule that the mere showing of an opinion, even if relevant in a particular arbitration, is not sufficient to sustain a challenge. The deciding authority in this case stated that the test to be applied was whether the opinion expressed was specific and clear enough that a reasonable and informed third party would find that the arbitrator will rely on such opinions without giving proper consideration to the facts, circumstances and arguments presented by the parties in the proceedings. Furthermore, it was held that where an opinion was expressed in a scholarly capacity and not in a decision that could have a binding effect on the arbitrator, or where the statement made was a flexible general interpretation that left open a more in-depth analysis of the issues in a particular dispute, the test in question cannot be satisfied, and thus a challenge to the arbitrator cannot be held if one or both of these instances applied. The first instance is satisfied quite easily. It is not disputed that Dr. Gargin expressed his opinion as to the performance of contracts in a scholarly article and not in his capacity as an arbitrator during a dispute. The challenge to Dr. Gargin's position as arbitrator based on the opinion he expressed would fail on this point alone. Furthermore, it can be said that the second instance also applies to this case, as the opinion Dr. Gargin expressed cannot be said to be specific enough as to amount to more than just a general interpretation of the applicable law. The facts of the particular case at dispute and the arguments presented would provide an opportunity for an in-depth analysis of the applicable law as it applies to this case. Based on the above, if Rolafun were to successfully argue that a reasonably informed third party would be of the opinion that Dr. Gargin would rely on his previously expressed opinion, then the challenge to his position would nonetheless fail on the 2 points stated above. The second challenge presented by Rolafun to Dr. Gargin's position is based on the fact that he is connected on LinkedIn with all the counsel for both Rolafun and Jarndyce. This challenge to Dr. Gargin's position as arbitrator can be dealt with quickly. It is well established by the LCIA court that a personal or social relationship without more is insufficient to warrant an arbitrator's disqualification. This position is well supported by the LCIA court's previous decisions, namely LCIA reference 1303, LCIA reference 81132, and the case of Alpha v Ukraine. The latter case provided that the general rule was that there was no requirement on an arbitrator to disclose a personal or social relationship. Therefore, the fact that Dr. Gargin is connected on LinkedIn with all of the counsel for both Rolafun and Jarndyce is insufficient to warrant his disqualification. Rolofund have not provided any evidence of any involvement further than merely a connection via a social media website that can distinguish this case from the cited case law. Therefore, it is this connection alone cannot amount to a successful challenge to his position. The third challenge brought by Rolofund is based on a laudatory recommendation provided by one of the lawyers for Jarndyce for Dr. Gargan related to a case where they were both working a year ago. The issue at question here is the relationship between the lawyer and Dr. Gargan. What needs to be considered is, firstly, the period of time that has lapsed since they worked together. Secondly, whether the relationship is ongoing. Thirdly, the extent of the connection or relationship at that time. And fourthly, whether the case they worked on involved similar facts or legal issues to the present case. The case of Universal Compression v Venezuela provides support for the argument that, as is the case here, a year is a sufficient lapse of time to render a prior professional relationship meaningless for the purposes of challenging the independence or impartiality of an arbitrator. The length of the relationship is irrelevant, provided that it is not ongoing. Likewise, this case provides us with authority that the extent of the connection between Dr. Gargan and counsel for Jarndyce is in itself not sufficient to establish a successful challenge to his position, as the parties involved in that case were not the same parties represented at the dispute in question. It is well established that the familiarity between members of the bar is not sufficient to compromise the independence or impartiality of an arbitrator if he happens to be a member of the same chambers as the counsel of one of the parties. See as authority for this point the case of Lake Airways v Aerospace Limited. It would be impractical that the relationship between barristers is overlooked, but the relationship between counsel serving the same function was not by the mere fact that they were a solicitor as opposed to a barrister. Due to the standards of professionalism of the individuals involved and the function they perform, it would be unreasonable to hold that the previous relationship between Dr. Gargan and counsel for Jarndyce was sufficient to raise a justifiable doubt as to his independence or impartiality. With regard to the final consideration, it is submitted that the facts and legal issues of the previous case Dr. Gargan and counsel for Jarndyce worked on are sufficiently distinguishable from the current case so as to avoid any direct parallels being drawn and prejudgments being formed. Fourthly, Rolofund have brought into question Dr. Gargan's independence and impartiality based on a personal encounter with a member of the board of directors of a company called Funny Tank Engines Limited, which shares a parent company with Rolofund. As stated previously, the general rule is that there is no requirement to disclose a personal relationship. LCIA reference 1303 provides a case for the removal of an arbitrator where enmity exists between the arbitrator and counsel. Based on the self-evident tension and ill feelings that had arisen as a result of counsel bringing a challenge, the arbitrator in question was disqualified. He was not found to lack independence, but the ill feeling in the present proceedings compromised his position. However, the relationship in question here is not between the arbitrator and counsel in the present proceedings, nor is it between the arbitrator and a representative or employee of one of the parties to the dispute. The relationship is between Dr. Gargan and a member of the board of directors of Funny Tank Engines Limited, a completely separate legal entity. It cannot be said that there is a sufficient connection here to raise a justifiable doubt as to Dr. Gargan's independence or impartiality. This concludes our counter-arguments in respect of the challenges put forward by Rolofund as to Dr. Gargan's suitability as an arbitrator in the current proceedings. Based on the arguments and authority we have presented, we believe that Rolofund have not presented any justifiable doubts as to Dr. Gargan's independence or impartiality. It is therefore requested that the hearing rejects this challenge. Thank you for listening. This concludes my submission. If the panel has any questions, I would be very happy to assist.